Hi, welcome to C.A.R.E.ing Conversations. My name is Joy, and we are coming to you from the Center for Abuse and Rape Emergencies. I have two advocates with me here today, and we want to do a quick overview of some of the services you may not know about and go in depth about our legal advocacy program. I have Shannon here. And Shannon, will you introduce yourself and talk about some of your outreach efforts?
Sure. My name is Shannon. I am the Sexual Violence Outreach and Awareness Coordinator here at C.A.R.E.ing. We go out into the community and do outreach events. We just started working with children. The program is called Safer, Smarter Kids, and we go into the schools and we talk about sexual violence prevention is what it's actually called. We do just preventing the onset of that. So,
how to be safe.
Right, safe touch, safe and unsafe secrets, stuff like that.
Okay, well, thank you. And we've always worked with children, but COVID, so it's been hard to do some of those outreach efforts.
Right,
it's so nice to be back presenting the programs. Even during COVID, we've always represented people in the courts, had legal advocates, had Miss Dayna Bouchard with us, our attorney, and can you go ahead and talk about it?
Joy, my name is Dayna Bouchard. I am the Injunction for Protection Project Attorney here at C.A.R.E. I help all residents of Charlotte County, male and female, with the application and representation of injunctions in court.
Yes, and everything's free and confidential.
Correct. There's attorney-client privilege with the consultation, and obviously there's no charge for the members
Obviously.
of the community.
And like I said, we still have been doing that, even though the court's process looks a little different. Can you talk a little bit, I hear from advocates a lot, and I hear from survivors a lot. No, I'm not going to go to court. I've got a no contact order. I'm okay. What's the difference?
There's a big difference, Joy, in a no contact order and an injunction.
Okay.
A no contact order comes from a criminal court judge. So when the defendant who has engaged in a domestic violence situation or sexual violence attends first appearances and it's a violent crime, the state attorney's office will ask that a no contact order be entered between the victim and the defendant.
Okay.
And sometimes the defense attorney will make arguments against it and the prosecutors will argue for it. And then the judge usually, I would say most of the time, does enter a no contact order, and it is an order signed by a judge keeping the defendant from the victim. And it's only the victim in the case. It doesn't follow through to the victim's friends or the victim's new boyfriend or your neighbor.
Oh, or the workplace, maybe.
Or the workplace. It's attached only to the person. So it would be preventing me, the defendant, who battered you, from contacting you.
Okay.
But it wouldn't prevent me necessarily if I had a relationship with your daughter or if I was friends with your neighbor. Those people I can still communicate with. Okay. I just can't contact you. I can't call you from jail.
And if the arrest doesn't go forward, that usually goes away.
Yes,
right?
If the case doesn't proceed, if the defendant enters a plea or they end up going to trial and they're found not guilty, at the resolution of the criminal case, the no contact order also vanishes.
Okay.
It goes away unless there is an agreement made with probation that a no contact order is entered, but that's way down the line. The thing to remember is that if the criminal case goes away, whether the survivor doesn't want to cooperate with prosecution or there's not enough evidence or there's an issue with reasonable doubt.
There's a plea.
There's many reasons the no contact order goes away. That's why you need to consider, as a survivor, an injunction, because that's a civil court order.
There's the big difference.
Civil court order. It's a completely different courtroom. The defendant is there, but he's not called a defendant. They are called respondents, and the person filing the injunction is the petitioner. So it's civil as opposed to the battery or the aggravated battery that this abuser has been charged with. Those things go separate. Your injunction application and the court date for the injunction and his criminal case are very similar, and I almost travel in parallel, like a train track. They kind of go at the same speed. They're in the same courthouse. You have court dates, but along the way through the train track, things change. You know, with the filing of the petition, usually that gets resolved faster than the defendant's criminal case will. Okay. So that's why we work with survivors on getting the injunction in place, at least applying for one, trying to get a temporary injunction, and get that going while the criminal case is also pending, because that's going to be carried on by the prosecutor, and there's different aspects with the criminal case as to the civil.
Sure, and the premise is the same for those two.
Correct.
I mean,
Safety.
sometimes people call it injunction for protection, sometimes they call it restraining order,
they're
stay
all the
away, they're all the same.
Right.
But what Dayna has so eloquently stated is a no contact is criminal, injunction for protection is civil.
Correct.
And can be on a permanent basis.
Yes, an
Okay.
injunction can be.
And everybody has a hearing, everybody has a chance.
Correct. The
Okay.
respondent and petitioner are both served by the sheriff's department personally
Okay,
with a copy of the petition. So if I filed a petition against a boyfriend, the sheriff's office would then serve him with the
Okay.
petition and the court date. And then I would obviously go to the courthouse and pick up my information, and I would know what my court date is.
and how long does all that happen? For
It's
the
about
temporary, when you
2
file?
weeks. You meet with the attorney, we discuss the options. If we end up filing it and that's the avenue that the survivor decides to go, by the end of that day or early the next business day, we will we will
Okay.
call a court, and we will speak with the clerk's office, and they will let us know if the judge granted a temporary injunction, which
Okay.
holds us over until the final court date. So I filed an injunction today, and I called the clerk's office, and she said, Miss Bouchard, your injunction has been granted. You'll need to come to the courthouse to pick up your packet and find out your court date.
Okay,
And then you take a breath
and
got your
call a C.A.R.E. advocate,
yes,
right?
call a C.A.R.E. advocate definitely and talk to them about what's going on, and then you'll know what your court date is. You'll find that out at the clerk's office, and then he or she will also. Both of you will then be required to go to court.
Right,
And you
right.
each are sworn, and each person would provide testimony. And then
Okay.
if you decide to come to C.A.R.E. and it's something that I assist
Mm-hmm.
you with, I would then sit with you in court and represent you and ask you questions and question the respondent and
Yes.
make arguments to the court on your behalf.
And that's so important. Remember, civil, criminal.
Correct.
Okay?
Very different.
And the basis is the same. You need to be in fear. And certainly someone who has been injured before warrants fear of being injured again. We know that.
Right.
That's how it works. The sexual violence injunctions are a little more difficult.
A little more difficult.
Yeah. What comes to mind, Shannon, that you want to ask? I know there's different things that people think they understand,
Right.
you know? Well, okay, I went to the courthouse, I picked it up, so I'm good, right?
No.
Something else gotta happen?
Not something else not happen.
Yeah.
You probably want to contact C.A.R.E. and either reach out and get in contact with an advocate, and they will then loop you through to me, or contact us at C.A.R.E. and they will give you my contact information. We really don't want survivors feeling as if they need to fill the packet out alone. It's very daunting. It
Yes.
even takes me a while, and I've been doing this for years.
Right.
It's about a 50 to 20 page packet, and it requires a lot of information. And if it's not done
details.
right, it could affect your case. If
Right.
you forget a detail that you might not think is important, but an individual that's trained in this field would know, oh, that's super important. We
Right.
need to include that. And you might think, well, does she really need to know that he has mental health problems and he's off
yeah.
his meds? Why does the judge need to know?
Does he
It's
really need
very
to know?
important.
He, just
Right.
bought a new weapon?
Exactly.
Yeah.
So there's
Yes.
things
Yeah.
that there's questions in the packet that if they're not answered right, it could affect your chances of not getting a temporary injunction.
okay.
It's not to say that you can't do it on your own, because it's not difficult. I mean,
Right,
it's
it can be done.
definitely can be done. We just have trained advocates here. I'm employed here. We are here to help, so we would just prefer to help you, because if you have it done right, even if you don't want to talk to me or you don't want an attorney, that's also fine. An advocate can help sit with the survivor and also go over the packet. So if the whole lawyer attorney thing is too much, that's not a problem. Advocates can also assist in the filing of the packet. They'll help you if they can't give you any legal advice, but
Right,
an advocate
right.
can definitely say, oh, this right here says you have to write down a narrative description of what happened. So an advocate can help read the packet, they can help
Right.
describe it, maybe if the words are confusing. But it's anyone off the street can do it.
Right.
Anyone
And
can pick up a
what's some
packet.
of the things that you thought of?
What do you think one of the biggest problems victims face in reference to restraining orders and filing them?
The most difficult thing I think that survivor victims face in this whole process is that you still have to consistently deal with your abuser.
Right.
Because you'll meet with me and we'll decide, and I'll decide if you have legal grounds to file an injunction, because there's the law is in play here. So just wanting one doesn't necessarily mean you'll get one.
Right.
There's specific categories that have to be included and covered in the injunction, and you have to articulate, that you're a victim of domestic violence or an assault or an aggravated battery, and that you are in continuing fear of future harm by that person.
Right.
So you need
But he went to Minnesota, so forget it.
Again, there's different circumstances with that fact pattern that may or may not give you enough to file one, so those are things that you need to consider and probably talk to an attorney about. If you don't want to, that's totally fine.
Well, how about those victims who think or hope, or he said he was leaving the state? Is their injunction still good?
Yes, the injunction, if you have an injunction here in Florida and he leaves the state, it's enforceable in any county in our state.
Okay.
There is some federal law that an argument can be made that if he was in Minnesota and you had moved there and you had an active Florida injunction, an argument could be made. I don't know if law enforcement would pick him up on a Florida injunction if he's beating you up in Michigan. So your injunction is in the state. There can be arguments that can be made. It depends on the nature of it, the gravity of the abuse, etc., how far away from Florida,
Yeah. And well, I guess I'm more concerned about victims letting down their guard, because if they think he's gone, does it have to be served on him? It can't just be.
He has to be served.
Okay. So if you haven't seen him in days and you're like this, maybe not.
Right, because the sheriff's office will have to serve him with your packet.
Okay.
So whatever the petition that you filled out, say that you went and you didn't want to talk to an attorney, it made you too nervous, and you had an advocate help you.
And look how nice, no reason to be nervous.
We always want to help. So,
Exactly.
So Miss Joy went to the first floor, she got her packet, she sat in the clerk's office, it took you about 45 minutes, you wrote everything down, you turned it back into Madam Clerk. She said, okay, give me a call about 4 o'clock today. So Miss Joy does all that. She calls at 4 and she says, hi, my name is Joy. I filled out an injunction today. Can you let me know if I got my temporary? And the clerk will say, yes, Joy, you did get a temporary, or no, you didn't. You'll need to come get your paperwork.
Okay.
So when you're like, well, what does all of that mean? So if you fill this out on your own or just with an advocate, if you don't get a temporary, you have no legal protection from your abuser.
Right.
And
from
the time that the clerk's office has received it, in the next few days is going to be a very dangerous time, because he will be served with your injunction packet, because he's a party to the case and he has due process rights. So he needs to be served with that and be notified of the court date. And if you don't have a temporary that was granted, say that there might not have been enough evidence, or the judge didn't find it credible, or whatever her reasoning is for not granting a temporary, you're now kind of in the open. So this is when you need to speak to an advocate, and you need safety planning. You need to speak to an advocate about an exit plan or how to stay safe, because your abuser will know what has been written. So that's none of this is secret. He will know, or she will know, whoever your abuser is. At some point during this process, they will be given that packet and they will flip through it. And sometimes that causes more damage for a survivor than not getting one.
And one of the very important things, and always is the victim's choice, will the threat of going to jail, will the threat of getting in trouble mean anything to your abuser?
And if it doesn't,
definitely call the 941-637-0404. Yeah. Talk to a sexual violence advocate, talk to a domestic violence advocate at 941-637-0404. Learn how the process works. Dayna's done a great job of, yes, you can get a temporary the same day, but if that doesn't happen and this doesn't happen. So do that safety planning, talk to the advocate, share what is going on, so the advocate can help you decide. Is this a good idea for you or not? You know?
The advocate is even more trained in that, and the advocates will know and be able to assist in a safety planning or an exit plan, or what do you do in the interim? Do you not have a place to stay? Do we need to discuss shelter stay? That's why
Long list.
your advocate and myself, we work somewhat together, but everything that you and I discuss as an attorney, or even if we just have a consultation and they have some questions and they want to know about an injunction and they say, look, Dayna, I'm not ready to do this. Everything is still confidential.
Right.
Nothing that I discuss with survivor is relayed to anyone ever. It doesn't go to Joy. I
Right.
don't tell anybody at C.A.R.E. I don't tell your abuser because I am bound by attorney-client privilege. And so
Make sure you're safe when you're making that call
yes, you
too.
need to be in a safe place. And I always verify that with the survivor. I have codes, and there have been times when the abuser has walked in and I ask them yes/no questions, and I pretend as if I'm a salesman. So there's different things
Right,
that
right.
we can do in conversations about safety, but those are things your advocate is best trained in. And then your advocate will loop you into me if now you're going down the path where you have questions about an injunction and should I do this and what happens if this. That is kind of a little outside of your advocate's purview. So then your advocate will say, hey, why don't we just
Right.
refer Dayna? Let's have you sit down with her or have a phone conference with her, and then you can hash that out. That way you
And don't be afraid to make the phone
Exactly.
call.
Oh,
You
yeah.
know, safety is the number one priority. And it may be a criminal court, it may be shelter,
Right.
it may be making a plan to go safely
Right.
somewhere for a couple days where you get a good night's sleep.
Right.
You know, there's lots of ways to approach it, but don't ever be afraid to make the phone call.
Right.
Look at our website for hints, at C.A.R.E. Charlotte County. Look at Facebook. We post this on there. We have several different conversations coming up. We definitely like to know what you'd like to hear.
Right.
If you want to hear more about outreach efforts and Shannon working with children, if you would like to learn about the bigger organization that helps fund these programs, the Florida Council Against Sexual Violence, if you have legal advocate questions,
Right.
we're here to do that. And we're here 24 hours a day, free, confidential, 941-637-0404. We want to hear from you, and we want to help you learn to keep yourself and your friends safe from violence. Thank you.